Generally speaking, divorce is a serious life event that can affect one's immigration status. The timing of divorce is substantially critical because it impacts whether someone can keep their permanent residency, if that permanent residency was achieved through the marriage. So if someone gets married to a U.S. citizen, obtains a green card as a result of that marriage, but the marriage does not last 2 years following the receipt of that green card, then that person's conditional green card will be terminated unless the person can demonstrate that the marriage was entered into in good faith and that it was terminated through no fault of that individual. There is also the consequence of extending the period of time you have to wait to be eligible for naturalization. If you are still not married to the U.S. citizen at the time you are eligible to apply for naturalization based on that marriage, you will have to wait 5 years to be eligible to apply. An area of the law that a lot of people like to talk about, particularly divorce lawyers, is the affidavit of support. The affidavit of support is an accompanying document when a marriage case is submitted to the Immigration Service. The affidavit of support is filed by the United States citizen. It is essentially a contract between the U.S. government and the citizen saying, I will make sure that my spouse does not become a public charge. And divorce does not terminate that promise. So the U.S. citizen is on the hook, so to speak, to that contract with the government. Even if a divorce occurs, the length of that obligation is 40 working quarters, or we often look at it as 10 years. And there is not substantial case law that provides significant guidance on this topic, but it is something to be aware of and that some domestic attorneys will be mindful of as well.